You're going to have to forgive me being a bit boring, but I'm going to go through some statistics with you. I did do a PhD in the Irish Circuit Court, which is the family court. I recognise some faces here today, which is good. I'm going to start off with a very sexist remark. I know that I'm at a men's group gathering when all the empty containers for the milk are in with the unused containers of milk. Way to go, lads. So anyway, we have our differences and we should celebrate our differences. So my PhD was published in 2014. I'm a partner currently in Arc Mediation, and I'm doing a public-private partnership with WIT, which is Waterford Institute of Technology, trying to find a better way to assist families when relationships break down other than going to court. So if we look at the context of where we're standing, so in the late 12th century, paternal rights dominated. I don't know if you guys knew that, but back in the 12th century, because we adopted English common law, fathers owned their children. So post the breakdown of a marriage, the fathers actually owned the children in the same way that they owned chattels of the marriage. And women had no rights of visitation, no automatic rights of visitation, and no automatic rights of custody. So it wasn't until 1839, is that right? Yes. That women actually, under a piece of legislation, women got the right to actually seek visitation with their children and to seek custody. So we're 177 years later now, and we have a swing of the pendulum where maternal rights dominate. So this question really is about society, and what are we as a society doing, and how are these swings and roundabouts coming to impact on how we deal with the issues of breakdown of marriage. So we have a world of competing parental rights, over 177 years. It went from fathers owning the children to effectively a de facto situation where maternal rights dominate now. And should we not, and this is, I always say that I'm not a woman's rights advocate, I'm not a man's rights advocate, I'm a children's rights advocate. And I think we should always begin the discussion with, is it not about children's fundamental right to have a relationship with both parents? Now those both parents could be man and man, woman and woman, woman and man, whatever that diverse family that is that presents, but children have a right to those parents. So the empirical research that I did was as I said, in the circuit court. I went all over Ireland. I observed 1,200 cases, 8 circuits, so I did all 8 circuits. It was a 145,000 word thesis. I can send a link to David who can send it on if anybody has the patience to read 145,000 words. I interviewed 13 judges, and I did interviews with court registrars and court clerks. So I was holistically examining how does the Irish family court work. That's what I was doing. So 96% of the children were in primary care of the mothers in the cases that I saw. That's just an overwhelming statistic that says the primary carer in Irish society is a woman, a mother. In all cases, it was the women who unilaterally withheld access. So in the smaller number of cases where the father was the primary carer, there was no case that I saw where the father withheld access. So all of the withholding of access was being done by the mother. There were 18% of cases where they were delayed by between 3 and 4 years. 10% of the cases were filed between 4 and 5 years before coming to court. 6% between 5 and 6 years. 3% 6 to 7 years, and 2% had been over 7 years waiting for their case to be heard. Now, if we think about that for a moment, the timelines for, say, divorce, I was looking specifically at judicial separation and divorce. So the timelines to judicial separation is 1 year apart. Timelines for divorce is 4 years apart. So the divorces that people who had already waited 4 years were an averaging of 3 years more before their case was heard. So 7 years. That's the whole childhood of a child. That's the whole childhood of any child. So it's not so much for me about the parents, it's about the delays and the impact that has on children and the children's right to know both parents. The shortest divorce I saw was 30 seconds. No evidence was heard and neither litigant was sworn in. Both of those would be in breach of the constitutional obligations on the judge, but I won't name the judge. The longest hearing that I heard was 5 hours. There was only one case at a 5-hour hearing. The average for a consent divorce is 5 minutes in front of a judge. The average for a consent separation is 7.5 minutes, and a contested divorce average was 20 minutes. So if you think about that, contested, in other words, and mainly what people are fighting about is children. So 20 minutes is the max amount of time, the average amount of time that people were getting to argue their case in front of a judge. So the idea, the misunderstanding that people have that they will get into court and get to have their say and get to explain to the judge all the reasons why they should be seeing their child or the other person should not be seeing their child, that doesn't happen. It very rarely happens. The norm is that there isn't the time for that to happen. Men are nearly 3 times more likely to leave the family home. And where women do leave, in 99% of cases, they take the children with them. So that is that maternalistic ownership space that we as a society currently operate. The overwhelming majority of applications were made by women, which defies the original concern of different groups back when divorce came in, that there would be floodgates of men looking for divorce. In fact, it's never panned out that way. It's actually women who are looking for that legal disconnection. Where a court ruled to allocate a greater percentage of the family home to one spouse, in 95% of cases it was to the woman where there were children. In 93% of cases, children under 12 resided with the mother. And only 1% of children that I observed the cases in court were in shared 50-50 parenting arrangements. One of the judges said that mediated agreements that came into the courtroom were quite poor and not capable of legal enforcement, and that would be also my experience of looking at the case files. Judicial quotes about children. So Judge 1 said that the younger children should be left with their mother. Judge 7, it said that there were many cases of alleged sexual abuse that he felt were being used as a strategic tool as against having validity, but how is a judge going to know what is or isn't a real allegation? Judge number 1 said that parenting agreements should be put together by experts. That was a roundabout way at the end of an interview for this judge to say, I haven't a clue how to figure out how I should be doing parenting arrangements. And also it's quite time consuming, and it's not the business of a court to sit down and work out, does Mickey have friends that he sees on a Thursday, and is Mari doing ballet on a Tuesday, and 10:30 is swimming on a Saturday? And so that should be slowly worked out with parents so that parents can both parent in and around the lives of their children. Judge 7 said, very honestly, I can manage short bursts, that is in the family court, but if I had to do a long stint, I would go mad. And actually, I totally get that. Because it's distressing enough for those of us to actually go through the court with our own case. I went through divorce myself. Think about hearing that continually, day in, day out. A lot of the judges in Dublin, here in particular, would see it in what's the name of the building? Thank you, Phoenix House. And a lot of those judges actually hear almost exclusively family law cases. And it is very dark. It's not, there isn't happiness in it. If you think about it, like one case after the other, and it's a dark battle with very common themes. There's very, very little complexity in family law in Ireland. There's a battle over the children and there's a battle over the stuff. And unfortunately, those two things are often mixed up, and children are part of the stuff. When you start a court case, you're starting a war. There's the judge that I met in Canada, an amazing guy, and he just said, I'd be out of business. I wouldn't have been a barrister. I wouldn't be a solicitor if what I think should happen. And he said families should not be anywhere near our courts, and they certainly shouldn't be anywhere near us as judges. My own experience of that particular war cost me $55,000, and I went back to college to study law because I'm actually an artist. That's my first profession. I still paint. But I was so hopping mad over my own experience and my lack of understanding of the law that I went back, did a law degree, and then did my own divorce. But it took me 3 years to get the knowledge to do it. I'm now, since 2014, I published my PhD in 2014. Since 2014 until today, I'm doing a pilot research project with WIT. I donate my time to the project because I haven't got the time to be filling in application forms looking for money. I mean, for me, it's too important about children to wait for some sort of bureaucratic move or wait for the state to do something. I think all of us have to do the piece that we can do to keep this agenda, keep this discussion going, and keep the reform discussion going. So I'm doing it with the college. I've got a team of 10 mediators. I train them all in. We're working directly with the courts. The good thing about doing my PhD is the judges are all aware of who I am. There's a certain level of respect for the research that I did. Whether they like it or not, it doesn't matter. They respect the fact that I did it. And what's happening now is that I'm talking directly to district court judges in Carlow and Kilkenny, and they're actually sending the cases to our pilot project. One of the judges in Waterford sent us 3 really, really difficult domestic violence cases, I think to prove to me that we couldn't do it, but we did. So the thing is, every piece of the human dynamic, of the human conflict, I believe can be mediated with intuitiveness, with empathy, with knowledge, and with understanding. The final agreements that have been reached so far, we've finished 50 cases so far, so 67% of those cases got final agreement. When I say final agreement, we are doing firefighting agreements first. We do 6-week agreements for parenting, 6 weeks agreements for maintenance, so that we can kind of begin the transition of trying to try out new arrangements. So it goes 6 weeks, 3 months, 6 months, 1 year, one agreement after the other. It's an iterative process, and we work it out step by step. So at the end of the first 6-week period, like 2 weeks before the end of the first 6 weeks, we meet with the parties again so that we get a new agreement in place before the existing one expires. At all times, we keep it linked to the court because that keeps everybody focused, and the case doesn't come off the list. I don't want anybody disenfranchised coming out of the legal system by coming to mediation, which is what is happening in some other instances. So if they can't come to agreement, I want their case to stay on the list so they can get back in there and get those orders if that's what it has to be. But so far, we're doing a pretty good job with people who come to us. And in 96% of cases, they're getting into those first agreements at least. In 69% of those cases, the fathers had no access at all. So these were fathers who had zero access. They were being completely withheld time with their children. And this improved dramatically. We got access for all fathers. So in no case in the pilot so far has a non-resident parent had less access time after, as a result of coming into mediation. And on an average, there was an average of a 13% increase of time with the children for each of the fathers, including overnights and weekends. And one father went from no access to almost 50-50 parenting. So, and obviously he was very happy. So what are the pilot innovations? So an appointment within 10 days, linked to the courts and solicitors. So if people already had legal aid, we got the legal aid solicitors to work with us. Solicitors also respect me because they realise I'm like a consultant and they're specialists. I'm just about family law. I know family law inside and out. And once these solicitors start talking to me, I'm like the neurosurgeon and they're the GP. They get it and they let me go. So basically, and there's just respect is crucial to this whole working together space. The pilot is means tested. It's by gender co-mediation, so man and woman mediating with man and woman. Active case management, we give 14 hours per case. Short agreements to create peace. It's available in the community, so we do it in existing community resources, like the FRC centres is where we use, because those buildings already exist and the administration already exists, and let's not make a resource issue out of this. And then access to other supports, like parenting courses, counselling, family therapy. So if we see that a family needs that, we get that in place as well. And children can express their views. So we meet children, and we've been trained by the Scottish Family Law Centre. So I'm going to start new research in January 2017 because I need more stats. This is about proving what's happening rather than talking about it. We all hear the stories, we all know the anecdotes. I want to prove again what's now happening. So I'm going back into the district court in January, February and March, possibly April and May if I can manage the time. But I'm going to observe district court cases, particularly around access, custody, guardianship, maintenance. And I want to build up a picture of what's happening. And in particular, what impact is the Children and Family Relationship Act 2015 having on the courts, and is it being used? In reference to the title of this conference, who cares about men? Well, I do. Your mothers do, your sisters do, your children do, your family does, and your neighbours do. And you, all of you, are part of who we are. You are our fathers, you are our brothers, you are our uncles, you're our cousins, you're our friends, you're our community. And we need to work together, men and women, to support the rights of a child to be loved by both parents. Thank you.